major ruling involving the Second Amendment.
The Supreme Court has just issued a major ruling.
Major Supreme Court ruling.
It's a case that legal experts will be watching closely when it likely heads before the justices.
So the Supreme Court has issued an order in the critical Second Amendment Preservation Act challenge that was pending in front of their court.
In the span of just 24 hours, the highest court in America delivered a verdict so devastating that it sent shockwaves through millions of gun owners across the nation. An 8-1 decision that didn't just reject a state's bold challenge to federal authority, it obliterated the legal strategy that conservative states thought would finally give them the upper hand against Washington. Missouri had attempted something unprecedented, something no state had dared try since the civil rights era. They built what they believed was an impenetrable legal fortress around their citizens, designed to shield them from federal gun control entirely. The result wasn't victory. It was a spectacular legal catastrophe that backfired in ways nobody anticipated. What unfolded represents more than just another court case about firearms. This was a constitutional showdown that revealed fractures within conservative legal philosophy so deep that even the most right-leaning Supreme Court in nearly a century couldn't bridge them. And the implications stretch far beyond the Second Amendment into the very foundation of how federal and state power interact in America. The $50,000 gamble that backfired. Missouri's legal architects didn't craft ordinary legislation. They engineered a financial weapon of mass destruction aimed directly at their own law enforcement. The Second Amendment Preservation Act created a penalty system so brutal that sheriffs across 114 counties faced an impossible choice: cooperate with federal agents or watch their personal finances crumble. The $50,000 fine represented just the beginning of what legal experts calculated could become financial ruin. A single officer working multiple federal cases could accumulate penalties exceeding $200,000 within 12 months. But the true genius, or madness, of Missouri's plan lay in its citizen enforcement provision. Any resident could transform into a legal bounty hunter, filing civil lawsuits against law enforcement agencies that dared collaborate with the ATF or FBI on gun-related investigations. Within 6 months of the law's activation, 47 lawsuits flooded the courts, creating a litigation nightmare that drained millions from taxpayer coffers in defense fees alone. County budgets hemorrhaged money not from actual penalties, but from the mere threat of endless legal battles. What Missouri had created wasn't protection for gun rights, it was a self-destructing legal bomb that exploded in their own hands. The sanctuary city blueprint that became a trap. The irony embedded in Missouri's strategy reveals something extraordinary about American legal warfare. Conservative attorneys borrowed their entire playbook from the progressive sanctuary cities they had spent years denouncing. Between 2015 and 2021, over 560 cities and counties declared themselves immigration sanctuaries, successfully blocking ICE agents from accessing local jails, using municipal resources, or obtaining information from government databases. These jurisdictions had established a legal precedent called the anti-commandeering doctrine, which the Supreme Court had repeatedly upheld. Constitutional scholars watched cities like San Francisco, New York, and Chicago create effective shields against federal immigration enforcement through careful legal maneuvering. Missouri's legal team studied every single victory, invested over $340,000 in research, and believed they had discovered the perfect constitutional loophole. Their logic seemed bulletproof. If liberal cities could block ICE, conservative states could block the ATF using identical legal principles. But Missouri made one critical error that sanctuary cities had carefully avoided, a mistake so subtle that even constitutional experts initially missed its significance. Once the Supreme Court identified this single miscalculation, Missouri's entire legal fortress collapsed like a house of cards. Justice Thomas stands alone again. When that 8-1 vote emerged from the Supreme Court, it illuminated something remarkable about Justice Clarence Thomas that most Americans fail to understand. Thomas has now stood alone in dissent or unusual positions 73 times during his tenure, more than any other sitting justice by a factor of 3. His judicial philosophy embraces originalism so strict that he willingly overturns precedents that have endured for over a century if he believes they contradict the Constitution's original meaning. In the Missouri case, Thomas didn't even author a full dissent. He simply noted he would have granted the stay, which in Supreme Court language represents the equivalent of declaring that 8 other justices missed something fundamental. Legal historians compare Thomas's solitary positions to Justice John Marshall Harlan's solo dissent in Plessy versus Ferguson, the 1896 case that upheld racial segregation. Harlan stood alone and was vindicated 58 years later with Brown versus Board of Education. Thomas's supporters believe he's playing an extraordinary long game, planting constitutional seeds for future courts to reconsider federal power limitations. His critics argue he's become so ideologically rigid that he's lost connection with practical governance realities. But Thomas's vote wasn't actually about firearms at all. What he was defending carries implications that extend far beyond Second Amendment boundaries into the fundamental structure of American federalism. The Bruin Revolution that changed everything. Just 3 years before Missouri's spectacular defeat, the Supreme Court handed down the Bruin decision that completely transformed Second Amendment jurisprudence in ways most Americans still don't comprehend. On June 23, 2022, the court established a revolutionary test requiring any gun regulation to be consistent with America's historical tradition of firearm regulation. This standard threw out decades of established legal framework and replaced it with historical analysis that's creating chaos in courtrooms nationwide. Within 18 months of Bruin, over 450 federal and state gun laws faced challenges in court. Judges suddenly had to become historians, examining musket regulations from the 1700s, dueling laws from the 1800s, and frontier gun policies from the Old West. The success rate of these challenges skyrocketed dramatically. Before Bruin, gun rights advocates won approximately 23% of Second Amendment cases. After Bruin, that number jumped to 67%. Lower courts struck down laws banning firearms in parks, churches, and subway systems. Age restrictions preventing 18-year-olds from purchasing handguns fell across multiple jurisdictions. Concealed carry prohibitions in 6 states were overturned entirely. Gun rights organizations filed over $89 million in lawsuits using the Bruin standard, winning far more often than losing. This raises a crucial question. If Bruin was already winning the war for gun rights through federal courts, why did Missouri feel compelled to create SAPA at all? The ATF factor. Nobody discusses. Behind Missouri's extreme reaction lurked a federal agency that has become the most controversial law enforcement body in America, and the statistics explain why gun owners harbor genuine terror. The Bureau of Alcohol, Tobacco, Firearms, and Explosives conducted 37,872 compliance inspections of gun dealers in 2023 alone, a 340% increase from 2016. These inspections resulted in revocation of 122 federal firearms licenses, effectively shutting down gun stores for paperwork violations that owners claim represent technical errors rather than criminal intent. The ATF has wielded regulatory power to reclassify items without congressional approval, declaring bump stocks to be machine guns and forcing over 520,000 owners to either destroy their devices or face federal felony charges. They redefined what constitutes a firearm to include partially completed receivers and frames, creating criminal liability for hobbyists building guns at home. Most controversially, the ATF maintains a database that, despite legal prohibitions against registries, contains over 920 million firearms transaction records. When gun dealers close their businesses, their records transfer to the ATF's National Tracing Center where they're scanned and stored indefinitely. Gun rights advocates call this a backdoor registry. The ATF calls it crime-solving infrastructure. Missouri legislators examined these numbers and panicked, seeing federal agents with power to criminalize gun owners overnight through regulatory changes that bypassed the legislative process entirely. But their solution to fight back created an even bigger problem that ultimately handed more power to the very federal government they were attempting to resist. The Supremacy Clause trap explained. Article 6, Clause 2 of the Constitution contains just 68 words that destroyed Missouri's entire legal strategy, and understanding why requires examining the most dangerous precedent in American history. The Supremacy Clause establishes that federal law represents the supreme law of the land, overriding state laws when they conflict. But Missouri's case becomes fascinating because they weren't actually attempting to override federal law. They were using the anti-commandeering doctrine, which the Supreme Court has repeatedly affirmed. States cannot be forced to enforce federal law, a principle the court established in Prince v. United States in 1997 when they ruled that the federal government couldn't require state law enforcement to conduct Brady Act background checks. Missouri believed they stood on solid constitutional ground. The problem emerged in their language choice. SAPA declared federal laws invalid within Missouri's borders. That single word transformed their law from non-cooperation into nullification. Nullification represented the doctrine that southern states attempted to use before the Civil War, claiming they could void federal laws within their territory. The North won that war, and the legal question was permanently settled. States cannot declare federal laws invalid. Missouri's attorneys insist the distinction is purely semantic, arguing that refusing to enforce a law and declaring it invalid are functionally identical. The court sided with the federal government. But here's the terrifying question that keeps constitutional scholars awake at night. If Missouri had changed just 5 words in their statute, they might have achieved victory. What the 8-1 vote really reveals. That Supreme Court vote tells a story extending far beyond firearms and reveals a fault line in conservative legal philosophy that threatens to explode. The 6 conservative justices include Amy Coney Barrett, Brett Kavanaugh, and Neil Gorsuch, all appointed specifically because of their originalist views and skepticism of federal power. Yet they voted against Missouri without hesitation, creating no close call or nuanced decision requiring extensive deliberation. This reveals that even the most conservative Supreme Court in 90 years maintains hard limits on how far they'll permit states to challenge federal authority. They'll expand individual gun rights through cases like Bruin and limit federal regulatory agencies through cases like West Virginia versus EPA, but they will not allow states to functionally secede from federal law enforcement systems. The implications stretch far beyond the Second Amendment into the fundamental structure of American governance. If Missouri had won, red states could have nullified environmental regulations, while blue states could have nullified immigration enforcement, fragmenting the entire federal system into 50 separate jurisdictions with their own rules. The conservative justices, despite their states' rights sympathies, examined that possibility and delivered an absolute rejection. Justice Thomas was willing to venture into that constitutional territory, which explains why he stood alone. His legal philosophy prioritizes constitutional structure over practical consequences, regardless of the chaos that might result. Meanwhile, other states are already rewriting their laws using the exact constitutional language that might actually work. And if they succeed, everything changes in ways that will reshape the balance of power between Washington and state capitals forever. The Supreme Court just rewrote the rules of engagement between states and federal gun control, establishing boundaries that will influence constitutional law for generations. What comes next will determine whether the Second Amendment grows stronger or weaker in your state, and whether the federal system survives the growing tension between competing visions of American governance. This conversation has only just begun, and the next move belongs to the states brave enough to test the court's newly established limits.